The next matter to come before the court this morning is Mark Clucas Senior versus Route 80 Express Inc. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are arguing on behalf of the appellant and would wish to reserve that time, let me know when you get started because I am keeping the clock this morning. The court has read the briefs and we are ready to see when you are.
Thank you, Your Honor. May it please the court, my name is William Scott Durkin, representing Mr. Clucas, who is the plaintiff appellant in this case. I would like to reserve 2 minutes for rebuttal. I'm not going to go over all the facts of the case because they're pretty clear from the briefs. What I would like to point out, though, is this is a summary judgment case. Therefore, the facts cannot be in dispute for the trial court to have granted a summary judgment. And I find, and I will argue, that there are several facts in dispute in this case. First of which, and I better do that right, there's no question that plaintiff took a drug test after an accident. The question is whether it was a positive test. Now, according to the standards, among other places set forth in the Federal Motor Carrier Safety Act, a positive test for marijuana metabolite, THC, is 50 nanograms per milliliter. Now, in this particular case, the result was 24 nanograms per milliliter. But there is some mechanism by which the MRO, the medical review officer, can look at this and say, well, this is a diluted sample, so I'm going to make it a positive, which is what happened in this case.
Well, the authority for doing that was alleged to be what?
It's alleged to be, well, it's in the Federal Motor Carrier Safety Act. But the question becomes, taking what would otherwise be a negative test and making it positive, is that not construing that particular fact of the flunk test most favorably to the defendant and not to the plaintiff, the party against whom the summary judgment is being made? I would argue that if the test came out at 50 or more, we wouldn't be arguing at this point. But it did. It came out at 24. So now we get into the subjective changing of the result from negative to positive. And I submit that that is an issue that should have been decided by a trier of fact when all of...
What was in the record with regard to disputing the method of calculation that reached the 40 result?
Well, they never did come up with a 50. They just said this is a positive test because it was diluted. It was diluted because there was some...
Well, what I'm saying is, what is the scientific background behind using a diluted sample from which to extrapolate a result?
It has to do with the specific gravity of the urine, I believe, and...
So in essence, you're saying that that is not a reliable test?
What I'm saying is that if they see that the specific gravity is at one point, then if they automatically deem that a positive, there should be some mechanism to test that, get your own expert cross-examination. But we never even got to that point because this was decided on a summary judgment. And the summary judgment, in order to decide it on a summary judgment, had to construe this test most favorably to the...
What was in the record to inform the court that it needed to construe this differently than it did? in the summary judgment proceeding?
The copy of the test results was attached to the record.
Was there, you're saying that the mechanism of the test was inherently unreliable and should have been construed in favor of your client. But did the court have the information from which it could have reached the conclusion that you wish us to reach in this case?
I'm not sure that they had anything more than I'm telling you now, which was that there was a 24 nanogram per milliliter test that was deemed to be positive because of the specific gravity. There's something else, and I can't remember what it is.
So in the record, we have nothing but the testimony regarding the dilution test, and we have nothing presented to the court by way of challenging that dilution test as being not accurate.
That would be correct, Your Honor.
Right, thank you.
The court, this was a wrongful discharge, a violation of public policy case. The court says in your reciprocal, that you had a reciprocal burden, obviously, and you didn't demonstrate that that your client was discharged in violation of public policy under the clarity element. And I'm not sure I'm quite getting that, so maybe you could articulate what your argument is in regard to that, and what you argued before the court, I guess, more importantly. Not so much what you're arguing now, but what did you argue then?
All right. That's getting me on to my next point here.
Okay.
Which is this company wrote a manual whereby they said certain things about what happens if somebody fails a drug test. And if I can, I won't quote it exactly, but it says, this is written by Route 80 Express. Route 80 Express is required, that's the word they use, by the alcohol and drug ruling, and I'm not sure what they mean by that, but to provide a driver with an opportunity for treatment. This is after a positive drug test. And they go on to say a driver must, they use the word must, be referred to a SAP, substance abuse professional. So even if we take this test as positive, they still didn't follow their own procedure.
But I guess what I'm getting at is the clarity element on the wrongful discharge, because, the wrongful discharge in violation of public policy, because doesn't that go more to just they didn't follow their own procedures, so that's a breach of contract maybe that.
Well, there's a
wrongful discharge based on that.
Some of the cases I cited, and most specifically Majestic, I believe it was MHADC, I think, they're talking about when there's a company policy that said, in that case it was, I believe that case, it was one where they said they were not going to pay somebody for overtime, accrued vacation, if they were either discharged or they voluntarily quit. That was their company policy.
Excuse me, didn't the company policy say it would not pay for the treatment?
Right. But I don't know how they can square that with not pay for the treatment, but they're required to send him, according to their own policy. And it must be referred, they use the word must, be referred to a substance abuse professional.
Is the policy that you're claiming is the public policy related to the keeping drivers of motor carriers off the road regarding drug use, or is it related to a wage and hour claim? There seems to be this flavor that from the entry that when the summary judgment motion was filed, the response was this was a bad test, and so that makes the test a genuine issue of material fact. But there also seems to be some indication that the pleadings were the public policy. The reason why I got fired was because I was asking for information about my wages and my compensation levels, so therefore they violated some sort of wage and hour public policy. It's still trying to follow up Judge Carr's question, which was, what's the public policy that they
Well, I think the public policy that they violated is the not following their own manual, which the courts have said, if the manual, the courts must enforce the manual. And they were saying that when it's in favor of the person who wrote the manual.
But if that were the case, then every time an employer would not follow a policy at work, it would be a wrongful discharge in violation of public policy case? That can't be what the law is, can it?
Well, what I would suggest is that the employer should be a little bit more careful what they put into their policy. Because you
But I
get,
thought the whole point of that was that we as a state, we as a public body have an interest in this because it's a violation of the Constitution, a statute, that affects everybody, just not these two individual employees, the employer-employee.
but you can't really affect the entire society by a policy written by one employer that's supposed to apply to his or her employees only. So the policy that I'm arguing for is that they write this manual, they should be bound by it. And if they're not, if they don't follow it, then that is a public policy that's being violated. Now, we're not trying to create an implied contract of employment out of this policy manual. We're just trying to say that they should have followed it. They wrote it. It's inherent in that, the fact that they wrote it, that they should be the ones to follow it too, not just the employee. The other question becomes, what is zero tolerance? They keep saying they fired him because there's a zero tolerance policy. Well, they never define that. I don't know what that means. It could mean a lot of things.
Excuse me, doesn't it say that the employee cannot go back to work until...
So it's been evaluated
Right,
and treated.
right. So I'm not sure that is, your question is appropriate. There is a zero tolerance because there are mechanisms.
Well, I guess what I'm trying to get at is, yes, they're supposed to send him for treatment before they fire him, apparently according to this, as their policy. But the zero tolerance, it's unclear. Does it mean you can have no residue of marijuana at all in your system? Or does it mean you just don't flunk the test and you have less than 50 nanograms? Or something in between? Does it mean you can't be smoking marijuana while you're driving the truck? I mean, what about 2 weeks before and this stuff is still in your system? It's kind of like the Cleveland Clinic has a policy. You cannot be a smoker now and work for the Cleveland Clinic. But they have you sign a form that you acknowledge that, and it's in their policy manual. This is not clear as to what that means. Does it mean zero whatsoever, never smoke this stuff? Or does it mean not actually having enough in your system that you don't flunk the test? And that's an issue of fact that needs to be addressed.
You are just now reaching into your 2 minutes of rebuttal time. You may proceed or reserve as you wish.
Well, I just want to say that the breach of contract, the caption of the complaint says wrongful termination, breach of contract, right under that. There's language in the complaint that would support a breach of contract claim. But even if it's not that clear from the complaint, the defendant chose to make this a summary judgment, not a motion for judgment on the pleadings or a 12b6 motion. So once you do that, you are I'm allowed to supplement what I'm saying in the complaint with other forms of evidence, which are listed in Rule 56C. One of them is the affidavit, and so I supplemented that with the affidavit of Mr. Clucas, which is pretty clear that there was a contract he'd be paid so much that he wasn't paid so much. And I'm not saying that he was discharged because of that. We're talking about the drug test, but I'm saying that's a separate claim. How much time do I have left now?
Just about 30 seconds.
Okay.
May it please the court, my name is Neil Fincher, and I represent Route 80 Express, and thank you for the opportunity to speak to you this morning. The facts in this case are almost entirely undisputed. Specifically, Mr. Clucas, the plaintiff, admitted he was an at-will employee. That defendant, Route 80 Express, employed him as a truck driver. That he was in an accident prior to his termination, and the plaintiff admitted that he used marijuana within 60 days of that accident. He took a drug test after the accident and prior to his termination, and he admits that he was terminated by the defendant after the drug test results came back. During the drug test, he told the medical review officer that he had used marijuana. The medical review officer has the discretion, based on the findings of some metabolites and a diluted sample, and there was also a low reading of creatine, which suggests further that it was diluted, that it was in fact a positive test. And the medical review officer reported to Route 80 Express that the plaintiff had a positive test. What Route 80 Express knew is that their truck driver had tested positive for using marijuana. And so they terminated. His employment ended. As an at-will employee, he had no expectation of continued employment. Under Ohio law, Route 80 Express could terminate him for no reason, or even a bad reason, as long as it was not an unlawful reason.
So if the test was not positive, under that interpretation, the company can fire him anyway?
Correct. Yes. As an exception to the at-will doctrine in Ohio, the company cannot, though, terminate Mr. Clucas for a reason that would jeopardize established public policy. And that's what Mr. Clucas asserted when he filed his complaint in this case, that his termination violated public policy favoring employee accountings of wages and expenses. But when asked to produce the source of that public policy in discovery, the plaintiff admitted that he does not allege that there is a public policy for an employee to request an accounting. And that, at that point, essentially abandoned the public policy based on a request for an accounting. And it was either during summary judgment or an argument on appeal here that the plaintiff, I think it was an argument on appeal, the plaintiff first raised what is the other exception to employment at will, which is the existence of an implied contract. So the first exception is a termination that jeopardizes established public policy. I submit that claim is no longer before the court. There is no public policy. Judge Teodosio found that the plaintiff had not sustained his burden of establishing that there is a the clarity element. And so here we are now on the other exception, which I submit is not properly before this court because it wasn't pled in the complaint, it wasn't raised before the trial court. The other exception, if it were before this court, is a contract exception, is an implied contract, where if the employer's handbook and the other circumstances of the employment, including statements by the employer and supervisor and so on, would give rise to an expectation by the employee that the employer allowed of continued employment. And here, we don't have that. Mr. Clucas argues only that the drug policy said that the company would refer him to some sort of treatment as a result of a positive drug test.
And what is in the record about such a referral?
I do not believe that the company did refer Mr. Clucas, but that does not give rise to a claim for loss of a job. This is something that happens after a positive test. The company has the freedom, and they reserve the freedom, to terminate the employee. The policy that Mr. Clucas relies on is that a driver must be referred to a substance abuse professional. Route 80 Express, however, does not have to pay for rehabilitation or hold a job open for the driver after a violation has been made.
So if the employer does not make a referral, does the employer expect the employee to go out on his own and find a treatment facility, finish treatment, come back with a certificate and say, I'm clean, I want to return to my work?
First of all, the policy applies to drivers who are covered by the DOT regulations. Mr. Clucas argues, and I believe he's correct, that his accident did not fall under the DOT regulations. So his was a non-DOT drug test, and therefore it doesn't fall under the DOT rules. It's the DOT rules that Route 80 is referring to. Route 80 Express is required by the alcohol and drug ruling, meaning regulations, to provide a driver with an opportunity for treatment. This was not a post-accident test under the DOT regulations, so they don't apply. Under the DOT regulations, if an employee is referred to treatment, the employer has no obligation to reinstate them even after successful rehabilitation. It's merely, here is something that may help you correct this problem and avoid problems with it in the future. And the point for this court on this appeal is that this policy, number one, doesn't create a contract because there's nothing about it that requires Route 80 to hold Mr. Clucas' job open. In fact, it says the opposite. And therefore, they did everything that their policy required, even if it was binding upon them. And so, here we are with a claim that wasn't pled in the complaint, that wasn't argued before the trial court, that's been developed for the first time on appeal, and which would not satisfy the MERS test, which is that the circumstances of the employment, including what's in the handbook, including what's been said to the employee, are sufficient to create an implied contract. Otherwise, we would have the situation that Judge Carr pointed out, where any time an employer didn't follow the letter of a policy, you would be looking at a breach of an implied contract claim from that employee. And unless you have other questions, I think the case is just that simple. There's no claim before the court on which it could find any fact that would give rise to relief. And so we ask that the court uphold the trial court's grant of summary judgment and Route 80 expresses favor. Thank you.
Just about 30 seconds.
Okay, well, the most important point first. In our brief in opposition to the motion for summary judgment, Section F, defendant did not follow its own policy when it terminated the plaintiff's employment, then we go into the drug thing. So this is not litigated for the first time on the Court of Appeals. This was brought before the trial court's attention. Mr. Clucas, if he admitted to having used marijuana within 60 days of the accident, that's a stretch to say that he was under the influence of marijuana when the accident occurred. And that stuff does stay in your system a lot longer than alcohol.
Counsel, I'm afraid that you have now reached the end of your allotted time as well. Thank you for your presentation today. Thank you both for your presentations.
Thank you, Your Honor.
Court will take the matter under advisement and will issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.
All right, thank you very
We
much.
are adjourned until Thursday at Wayne County.
Right now,
How often does that happen?
Now,
Well, I guess that is close.
30 seconds isn't enough time to clear the throat. All right.
All right, Bill, behave. Take care of yourself.
Yeah.